Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi and I am the principal attorney at the firm. Today's review, we're going to be looking at some AI terms. So on this channel, we're going to be covering public-facing documents that implicate privacy. I think one thing that's really interesting that I've just seen is we've got a button here for legal, a button here for agreements and terms, and then we've got the button for privacy. Let's actually just dive into the terms for this organization. I'm just going to hover over products. So they've got something to do with bioresearch. Now, the minute I saw the word bioresearch, I started to think that there is going to be a healthcare, potentially, now I don't know that for a fact, but bioresearch to me and the word biopharma above, these insights give me, they set off bells in my thought process that state that there may be a healthcare component to the review. And in the United States specifically, I don't know in which geography this business is providing its products and services, but there is healthcare privacy legislation that is impacted depending on how these products interact with healthcare information, and it depends on the healthcare information. But the first thought that I had when I saw the word bioresearch is that there may be US federal privacy laws related to healthcare personal data that may be implicated as it pertains to the AI service terms. That's the first thought that I had. And I always highlight over the products because sometimes looking at the products and actually getting insight into them, I'm not going to click them because this review is on AI, but just having that insight knowledge is beneficial for you as a customer because you're also not only getting a privacy review, but also understanding how it impacts your business. If your business is in the healthcare space, having a review of the implications you have from a federal level, state level, if you operate in the United States, and then industry, right? There's so many factors and levels to the review and drafting of your terms. Now, if you're not in the healthcare space, right, the review of your AI service terms are going to be very different because you're not going to have obligations under federal healthcare privacy laws. But if you do, then these have to be drafted different to a business that's not in this industry. And that's the value of having a privacy counsel on your team in some capacity. Let's look at AI. The other thing I want to mention is that generally healthcare information and healthcare data is considered sensitive in the United States, right? In the European Union, and this is why geography matters, in the European Union, some healthcare data is considered a special category of personal data. Your business needs to take that into consideration if the healthcare data is going to form a part of input or output data depending on how your product works. Now, I don't have those insights. I'm just giving you general ideas of the types of considerations that a privacy counsel might let you know about if you are in the healthcare space. So this document is read in addition to the terms of service and the main service agreement. And I love that they have definitions. I've talked a lot about my reviews of AI terms on this channel. Not every customer has an AI counsel. Not every customer has a privacy counsel. Having the definitions is very valuable for whoever conducts the review on whether or not to utilize the services of a supplier. In this case, I presume that they're offering some type of product and service to a customer, so there will be a supplier in some instances. Let's talk about customer data. Now, this is terminology that is used consistently amongst AI terms, which is why we on the Data Privacy Lawyer are looking at the AI terms, because even though AI is not the same as privacy, privacy is always implicated in some capacity when it comes to AI. So customer data has been defined here as any data, right? I'm just going to quickly scroll down and see if they've explicitly used the word personal data. Okay, I don't see that. We're going to talk a lot about this section. This means any data, information, content, or code you submit, post, upload, transmit, or otherwise make available to the application services, including via the third-party services, except for such data specifically excluded in the definition, or is output. Customer data specifically excludes intellectual property, account data, usage data, including any such data that incidentally incorporates data made available to the application services, feedback, and aggregated or de-identified data. This definition, it reads two things. One, they've put any data, and then they've explicitly put what has been excluded. But in the exclusion, they have not excluded personal data here. Account data, now I'm not sure what that is. Let's see if there's a definition. There is not. Account data to me reads maybe username and password. Outside of those two identifiers, it appears to me that this definition incorporates the fact that personal data could be submitted, posted, or uploaded. Now I want to talk a bit about transmission. In some geographies, the definition of processing personal data is any operation or set of operations related to personal data. If you transmit personal data, you're processing it. There are responsibilities you have when you process personal data as a customer. So you need to be looking at this as a customer. You also need to be looking at this from a supplier perspective. Suppliers also have obligations under data protection laws when they process personal data, of which transmitting personal data constitutes processing. It's a processing activity, and it needs to be accounted for when you're putting in place your own privacy program from the supplier side and from the customer side. So we definitely know that privacy is impacted here just off of the definition of customer data. Now I see that they've used any data. I think it's wise to use any data. I think it would be valuable for businesses to also add explicitly that personal data is included in this term, any data. Whatever the case may be, as long as a business is capturing what could be in scope and also making it clear what is excluded, I think it's insightful for the customer that's reviewing this, whether it's the customer's counsel or whoever has the responsibility of reviewing contracts within the business. The last thing we're going to talk about is AI input. I really enjoy looking at these definitions because I think every AI is being utilized differently by different organizations depending on their industry. Now, we know that this organization offers some type of pharma product, so they're at least in the healthcare industry. Now, whether or not they are implicated by the obligations under HIPAA, which is a federal privacy legislation, is another story to be determined and is insights that generally are captured by Privacy Counsel in their intake form. AI input means customer data submitted or made available to an AI service by you. For clarity, input into an AI service may consist of both customer data and data that is not customer data, for example, suggested prompts. Only the customer data component of input into an AI service shall be considered AI input. Okay, that's interesting. So I think going forward, it would be valuable. Maybe it's something that's only distributed under an NDA, which is a non-disclosure agreement, but it's fun to see what constitutes an AI input. I don't know the specifics related to this product, but I think the exclusion, like the qualification of what constitutes AI input, is really valuable from a protection standpoint for the supplier, but also from a understanding and due diligence perspective of the customer to see what is and what is not covered. Let me tell you why that's valuable generally, not just exclusively from a privacy perspective, but from a legal perspective. The business, the supplier, right, when they qualify what constitutes AI input, they're essentially giving themselves a disclaimer that limits their potential liability if their tool is used in a manner that's inconsistent with these terms. Now, I apologize if that sounded very legalese, but essentially, broken down into simple terms, the qualification here means that if you as a customer provide AI input that is inconsistent with what is going to be covered under this definition, you have no recourse in the event that your usage of this tool goes poorly. That's what that means, simply. And I think this has been drafted in very explicitly by the AI counsel or whichever counsel has drafted this to allow the customer to understand what each sentence means, but also to understand what the cap is going to be on a customer's use of this tool. If you have a privacy counsel review this for you, you are going to see that there's so much insight that you as a non-legal professional may not know about the terminology. That could be valuable for you to know based on your usage of this tool. So we only got through the definitions. If anybody watches this video and wants me to do an entire review, leave a comment below and I will definitely do an entire review of each provision that implicates privacy. We only talk about privacy on this channel. And so if you want me to do a full review, leave a comment below. I hope you enjoyed this review. If you have comments about what I've suggested in this video, leave a comment as well, and I'll see you in another one.